All right, well, we are right at noon, so let's get started. Welcome, everybody. My name is Lee Schwartz, and I'd like to welcome you to the second webinar in our 2024 veterinary series titled Risky Business, Avoid Legal Traps in Vet Clinic Handbooks and Terminations. Like I said, this is number 2 in the series. I will have more information on our upcoming ones at the end. Now, before we get started, I want to take a sec and just say a few words about SVA and our history working with veterinarians. Actually, I know a lot of the same people attending this webinar have attended our past webinars. So let me just say briefly that we are celebrating our 50th year this year. And one of the main reasons we've made it this long is because of our consistent goal of remaining independent. And by helping veterinary practices with profitability, growth, and overall business strategy, we help position them to remain independent as well. Our mindset is that when you're a practice owner or shareholder, you have to work with someone who's more than just an accountant or tax preparer. You need someone who's a true advisor working collaboratively with you. So anyway, that's my sales pitch. As far as this webinar goes, please send in any questions you have as we go, but we're going to wait till the end to answer them. If your question doesn't get answered, please reach out to me, and I'll make sure one of our subject matter experts gets back to you and gets that question answered. So let me introduce our speakers. Stephen A. DiTullio is an attorney and partner with DeWitt LLP. DeWitt has 130 attorneys and offices in Madison, Milwaukee, Green Bay, and Minneapolis. Steve helps clients with employment law compliance and defends businesses in litigation. He works with a wide range of clients, including trucking companies, manufacturers, bovine insemination companies, and of course, veterinary practices. On the SVA side, we have Andy Slinger and Nate Drykosen. Both Andy and Nate are principals in our healthcare group and have been leading our work with veterinary practice groups for several years now. They work with practice owners and practice managers on growth, profitability, compensation, and of course, tax strategies. So with all that being said, Steve, I'm going to hand it off to you to get started.
Thank you, Lee, and good afternoon, everyone. I'm really pleased to be here again with my peers over at SVA, Lee, Andy, and Nate, to make this happen. This is the second of our 3 webinars on various employment issues. Something I hold near and dear to my heart are employee handbooks. And I will start off with a few comments, and then Andy will be doing some presentation from his perspective on this issue. And then we'll move on to termination firing issues. Really fun stuff there. So as far as employee handbooks, I'm first going to sort of address this in a non-lawyer way. And what I mean by that is there is no doubt that policies and a well-written handbook can help when disputes arise and claims come along. But don't forget that that's not the number one reason to have an employee handbook. The number one reason to have an employee handbook is that it is an incredibly helpful and vital tool to communicate with your employees. Broad issues like your core values, your mission, things like a welcome statement, a history, all of those types of sort of broad, softer type items. But it also obviously is important to set forth some expectations and requirements as far as workplace conduct. And it also has, typically, most handbooks have sections on benefits, leave policies, things of that sort. I've worked with clients in developing a lot of handbooks over the years, and I often get asked the question, well, how lengthy should a handbook be? And the answer is that really depends on number of employees you have, which could impact the policies that you include within the handbook. It depends on how structured your business is. Do you offer benefits? Do you offer a lot of benefits? I actually have a couple of clients that offer few benefits and put more onto the salary side of things. Just depends on the nature of your business. I will say, in my experience working with veterinary clinics and hospitals and practices, it's rare that I come across a 50 or 60-page employee handbook. Maybe for a very, very large practice, it might be that lengthy. But in general, I would say for most veterinary clinics I've worked with, you're probably looking at 20, 25 pages, something like that. But it is an important tool to have, like I said, from a communication perspective. And I strongly recommend that if you are operating your business right now, your clinic, with just standalone policies rather than a combined handbook tool, I would recommend that you pull those together. There's almost, I would say, an expectation of a lot of employees, both veterinarians themselves who may be working on under a contract, but also the handbook will apply to them, as well as the rest of your professional staff. And if you don't have a handbook, it may seem a little bit odd in 2024 that you going into 2025 that you don't. So I do recommend a handbook. Now, let me talk about the legal part of it real quick. A handbook has a lot of legalities to it. It's not a contract, and any good handbook will reflect that, but it is important to understand that for things like bonuses, wages, benefits, if you say you're going to be giving those to your employees, to your staff, you're going to be expected to do that. So it does have some binding impact from that perspective. Additionally, I can tell you that oftentimes when disputes arise, as it says in this first slide, employment policies oftentimes are Exhibit A. And what I mean by that is whether it's an investigation by the EEOC or the Department of Workforce Development or the Department of Labor, or it's a mediation or an arbitration or an actual hearing, a lot of times policies are one of the first things that are introduced, or they certainly will be introduced at some point in the process to basically set up, I guess is a good way to put it, the expectations for the employee and what was perhaps violated in the handbook, or performance standards that weren't met, that were expected to be met as set forth in the handbook. So there is no doubt that policies that you insert into your employee handbook today could be Exhibit A, B, C, and D when a mediation or a piece of litigation arises at some point in the future, if unfortunately that happens. So there are legal ramifications for the language that you use within the handbook. And so keep that in mind. It's why there has to be very careful attention to detail. And in a few moments, I'm going to be talking about some of those details. When you review your handbook, which you should do regularly, and by regularly, I'll define that at least once a year. Some companies do that twice a year. I wouldn't recommend going longer than that because A, things change within your business. Do the policies reflect the business realities in 2024, or are they reflecting business realities from 2020? I recently looked at a handbook for a client that had several policies that have been inserted during the pandemic, which were certainly appropriate at that time, but really are no longer necessary. Has your business grown? Have you gone from 48 employees to 52 employees, which now means you have to have an FMLA policy in your handbook? You have to recognize that there are certain employee thresholds that are met, even at the 15. At the 15 employee level, you have now grown from just Wisconsin Fair Employment Act governance to Title VII. And when you get to 20, the Age Discrimination Employment Act, and so on. But the key point is that when certain employee thresholds are met, or are reached, you need to update your handbook to reflect that. Move on to the next slide. I always get asked, well, we don't want an overly lengthy handbook. We don't want that 50 or 60-page handbook, which I tend to agree, unless you're a very large company. That's, I think, overkill. But there are some policies that I would say are critical or must have, if you will, in your handbook. Better have an equal employment policy, because if you don't, a good plaintiff's attorney is going to point that out. There is an expectation that you have an EEO statement, and that should reflect both federal and state law. And if you happen to be located in the city of Madison or the city of Milwaukee, there are local ordinances with more protected classes than exist under federal or state law. So my recommendation would be that your equal employment opportunity statement reflects those local ordinance protected classes. You should definitely have, and I usually see this as one policy, a non-discrimination or anti-discrimination, anti-harassment, anti-retaliation type policy, with a clear indication as to who should be the recipient within the organization of any type of complaint or concern that employees have in those very sensitive and important areas. And you should have an alternative person designated, not just one. You want to make sure that EEO statements and harassment discrimination policies address things like disability and religious accommodations. And I already talked about reporting procedures. All of that needs to be there. Definitely have an at-will employment statement, and make sure that it is written correctly. For example, it shouldn't just say an employer is allowed to, under the at-will standard, to terminate an employee at any time for any reason, because that's not true. Under the at-will standard in the state of Wisconsin and almost every other state in the country, the at-will standard is on the employer side. On the employee side, employee can resign at any time for any reason. On the employer side, you can terminate at any time, but not for any reason. And if you're saying that, a good plaintiff's attorney is going to jump on that and say, well, any reason, that could be discrimination, that could be harassment, that could be retaliation. And I've had good plaintiff's attorneys do that. Your at-will statement should include any reason that is not inconsistent or in violation of any applicable federal, state, or local law. You should have a code of conduct or examples of unacceptable conduct. That's usually in a bullet point format. They tend to be similar from veterinary clinic to veterinary clinic, but you may have some things that are of particular concern or have had a bad experience with at your practice, and want to make sure you get that into your list of bullet points. Employee discipline, whether or not you're going to use progressive discipline or not, and if you will be using progressive discipline, what does that entail? Is there a verbal warning, written warning, final warning, suspension before termination, suspension for pay or without pay before termination, and then ultimately termination? So make sure if you're using progressive discipline, it is set forth, and make sure you have your out that says something like, hey, we reserve as a business the right to deviate from this depending upon the circumstances, something to that effect. Obviously, policies about compensation, benefits, holiday pay, all that type of thing. You should have employee classification, exempt, non-exempt, full-time, part-time, temporary, seasonal. That should be outlined. And a handbook acknowledgement that is signed by the employee, and a copy goes with the employee, and a copy is inserted into the personnel file. Now, again, these are the most critical elements. There are lots of other things that can be in a handbook, but at a minimum, these are items that you should be including. Common pitfalls. These are things that when I receive a handbook from a new client to review, or even a modified handbook that a current client has updated. I do sometimes see these types of issues, so I wanted to flag them with you this morning. Again, policies do not reflect business realities. I had a handbook that I looked at recently, and it referenced a couple of locations that the company no longer had anybody at those locations. That's a simple example, but you just want to make sure that it is updated based on where you are at as a business in 2024. Make sure your policies are not limiting your discretion. Again, I mentioned this with the discipline policy that might require a 4-step progressive discipline. Have an out for that. Likewise, for things like pay raises or bonuses, have an out that pay raise or a bonus is dependent upon the employer's discretion. Same with issues such as evaluations and things of that sort. Just make sure that there are, at the appropriate points, discretion built into your policies. One problem I've seen is employees are not informed of updates. Now, let me talk about that one for a moment. I am not a big fan of if you change one policy to reissue the entire handbook and get everybody to sign new acknowledgement pages. And the larger your organization is, the less I like that. Maybe if you have 3 or 4 or 5 employees, you could do that, but it just becomes an administrative difficulty the larger your organization becomes. So if you have an update, what you could do to just one policy, let's say you issued your handbook in January, and in March you want to add a policy, inform your employees of that new policy, circulate it in writing. Email is fine, or if you're still using a printed version, print it out and give it to people and have them sign off on that one policy, but don't necessarily reissue the handbook. Now, at the end of the year, maybe you've had 3 or 4 new policies or modified policies, changes have been made, then maybe that, as you get into January of the next year, then issue a new policy and with an acknowledgement page being signed, a new acknowledgement page being signed. Another pitfall, managers or supervisors are not familiar enough with the policies. You should make sure that you have sessions with your office manager or any other managers within your practice to make sure that they are looking at policies and understand them and review them regularly. Because the last thing you want, for example, reasonable accommodation. Maybe your manager hasn't ever dealt with a reasonable accommodation under the Americans with Disabilities Act or state law before. Maybe they aren't aware that accommodations have to happen. And an accommodation, can, as most of you are aware, can come in a lot of different formats, including a leave that is outside your normal leave policies. Well, that might need to be part of a reasonable accommodation. Your manager, office manager, if you have an HR department, they're probably going to be up on this, but some supervisors and managers are not always as updated on the implementation of policies. So make sure you're having communications training sessions with your managers or supervisors as needed. Don't make your handbook too complicated. Again, that 50 or 60 page handbook that has some policies that really are not necessary, or some language or issues that are just complicating things. A handbook is, I go back to my first slide. Again, it's a communication device. If it can't be understood or is not understood, you're interfering with the primary purpose of the handbook. So don't overcomplicate it. Make sure policies are applied consistently. If they're not, you're going to end up potentially with a discrimination claim. Make sure you reserve the right to modify, and include laws that make sure you're not including laws that don't apply to your company. Again, FMLA is, I can't tell you how many times I work with a client, I get the handbook, and there's an FMLA policy in it, and they only have 12 employees or 20 employees or even 30 employees. You're far from FMLA, and FMLA is a very complex and technical law. For any of you that are working, that have more than 15 employees, 50 employees. And there's a state FMLA and there's a federal FMLA, and they are not identical. So it can get complicated very quickly with how those interact with each other, the state and the federal, and also how they interact with workers' comp law and how they interact with reasonable accommodation. So don't include an FMLA policy unless you're at that 50 or more level. Now, I mentioned earlier some really specific items, but I don't want any of you to overlook these. One significant one is whether you are using the word must or should appropriately. I see a lot of handbooks that use the word should when they should be using must. Okay. Many policies have requirements. They're not optional. And as a result, that one word can make a world of difference in litigation or in even non-litigation disputes, and how you're communicating to your employees. So I would tell all of you, go back to your handbook this afternoon or sometime soon, and do a global search for should and must, and make sure you meant must where you wanted it, and make sure you, to me, the musts outweigh the shoulds. But take a look and make sure that that has been addressed. I see this one all the time, and I've had plaintiffs' attorneys just really run wild with this one. And where I see this mistake made, it's the third bullet point, is oftentimes in a welcome note at the outset of the handbook, or in perhaps a more sort of general about this handbook type section. Handbook contents are not guidelines, and they're not suggestions, and they're not possibilities. They are almost always requirements and or expectations. And the problem with saying, like in a welcome note, this handbook has set forth guidelines for behavior. A good plaintiff's attorney is going to say, well, that's a guideline. That's not a requirement. And if you really care that much about preventing harassment in the workplace, you would have had a requirement on that, not just some guideline or a suggestion or a possibility. And you might be sitting there saying, oh, come on, Steve, those types of things don't come up. Yes, they do. And that's one benefit of my doing presentations on things like handbooks, because I do see what comes up in litigation and what plaintiffs' attorneys try to seize upon as far as wordings, and things like must versus should, required versus guidelines. Those can make a big difference, as can make sure that you are including, but not limited to, having that type of language in lists. So, for example, in your performance list, you could have that the following are basis for disciplinary, but it includes but is not limited to the following. Also, make sure that at appropriate points where you're referencing laws, you're only saying applicable federal, state, and or local laws. You don't want to start opening up yourself or your practice to laws that might not be applicable. So make sure that that magic language is at the appropriate points in your handbook. Andy, I'll turn to you for the next slide.
Thanks, Steve. Great information. I think this is a great time to just pause and, just remind all of you, kind of how this series started. Nate and I work with vet practices on a daily basis. And what happens over time is we become your trusted advisor. And in addition to practices these days, we find many not getting good tax, consulting, HR advice. They're also limited on the legal support they have in their practice. And many of you think of all the hats that you wear. You know, you're doing QuickBooks on a weekend maybe. You're the hiring manager, the firing manager, and everything in between as the sole owner of your practice. And so a lot of times Nate and I will be asked questions that very quickly delve into the legal arena. Not only can we not give you legal advice, we wouldn't want to give you legal advice. And that's why we so value Steve. You know, Steve works with our clients. He works with the WVMA. He's an amazing resource for us, for you. And I want to start with a point that he made at the beginning. It had nothing to do with law. It had to do with credibility. You know, you think about when you're looking for a business to work with for any service, a lot of times, what's the first thing we do? We look up their website. No website may not mean anything, but these days it can be a red flag. I'd say the same thing with no handbook. You know, an employee that's your gold standard. That's your everything, and I think it can really just be one of those things that differentiates you. You know, even not even talking the legal side, it just, you know, puts you separate from your peers. So really encourage you to look at it. So from the practical side, what do we see? You know, we see everything. You know, when sometimes in our robust agendas, we just say, hey, let's take a minute and talk a little HR consulting here. And we bring up the concept of an employee handbook, and, you know, we get those deer in headlights look like, what? You know, so some of you, and it's okay, you know, you can start now. You may not have a formal handbook. You, as Steve said, you may just have, you know, policies here and there that have worked for 5, 10, 15 plus years. Some of you may have a handbook, but it's like, where is it? When was it last updated? Yeah, it's been that rainy day, snowy day, when I'm not so busy project, and that day, as you know, never seems to come here in 2024. And no matter where you are, it's like, okay, well, where the heck do I start? And what I would say to you is, again, it depends. Are you the sole owner where everything falls on you? Are you a large multi-DVM practice where you have different managers at your disposal? Whoever that person is, you know, you want to gather as much information as you have, formal, informal policies, and reach out. Who's that resource? You know, and my call to you is reach out to an attorney. And if you don't have that formal relationship established yet, this is the year going into 2025, you know, to do it. And is it going to be a time commitment? Yes, depending where you're at. Is it going to be an expense? Yes, but it's an investment in the current, and it's an investment in the future. It's an investment in your people, in your patients, in yourself, in your practice. And just to take a pause, you know, I can give you a couple examples, and I'll just give you the Reader's Digest. But, you know, very recently there was one situation. We're going to talk about the hiring process and about communication and about culture. But, you know, one situation where I suspect it probably wasn't a good fit from the very beginning. And I don't know what the employment agreement looked like. I don't know what the eventual separation agreement looked like, if there was one. But I think with better communication on the front end, with some better policies, some better employment agreements, you know, we would have had what turned out to be a messy, hurtful separation of an associate relationship. You know, that could have been avoided with, again, taking the time, investing the cost in a better legal process at the forefront. Another one, if we go to more of the staff level, protected class, okay? And in this case, the employer did reach out to an attorney, but it was, you know, a buddy, you know, maybe a lunch, maybe looking for some free advice. And while it was an attorney, it was not an experienced employment law attorney. It was, maybe more of a commercial general business attorney. And what was put in place, how the termination happened, wasn't good enough. There was litigation brought, and there was a settlement, and it was in the tens of thousands of dollars. Okay. So I'm telling you, it happens. And I'm telling you that I think Steve would say, and Nate would say, that it's happening more than ever. And I just think that it's that time now to, make an investment in your practice, in your people, and get that in place. All right. So what do you want in it? I think as Steve alluded to, it's the employee experience. I'm going to allude to the employee experience a lot. So everything that has to do with their employment in your practice, you want in there. Okay. And yes, all of the standard benefits, but I challenge you, we've had separate presentations, we're all in a battle for resources right now. Every day it's about retaining the people you have. And it seems like every day it's about finding that next person. We're in this perpetual proverbial hiring mode right now, and limited people to hire. And so you're all looking for, well, what can separate me? What unique can I offer? And remember, what's worked for 5, 10, 15 plus years doesn't mean it's going to continue to work. It's how do you sometimes reinvent yourself? How do you pluck that person from the next practice? How do you keep someone in your practice from looking? So consider those unique benefits when you're looking to update your handbook. And I always say, for those that we haven't gotten in front of, pull your key staff, pull them aside and say, hey, this is what we offer. What matters, what doesn't? And sometimes just rearranging, reoffering, changing it up, it can be a sum zero. It doesn't mean you're going to have a increased cost necessarily. You're just maybe shuffling the benefits around to get to the same place and to provide what's more beneficial, what's more meaningful to your people. As you get creative, as you look to change your offerings and differentiate yourself, make sure you consider and ask your resource, is this legal? Can I do this? In tandem, we get the question all the time, well, can I give Susie X and can I give Cindy this and Bob? And, can I legally discriminate? That's what I like to say. To different employees, can I offer different benefits? The associate, the staff, the techs? Again, it depends. Okay. So make sure you're always considering, in tandem with your attorney, is what I'm offering, what I'm putting in place. Am I setting myself up for action, or am I okay? So always make sure you know what you can and cannot do. All right. So a lot of times too, in your policies, you have to consider, okay, I got to make sure I'm complying with what seems like ever-changing, IRS code. Okay. And that's a lot of times where Nate and I come into play. And so again, within that patient experience, it's all right. What do I need to withhold for tax? You might think this is silly, but almost on an annual basis, we'll get a call from somebody who says, hey, I got my W-2 and there's no federal withholding or no state withholding. And something happened, with the employer. And now, guess what? There's tax owed. It wasn't withheld. It's not a good situation. Overtime, whole separate topic that we could present on. But as you know, there have been recent changes, who's considered an exempt employee, who is non-exempt. That again should all be very clearly covered in your policies and in your handbook. And then benefits. We could carve out health insurance here, and we have HSAs, we have FSAs, we have dependent care, we have all different kinds of structured, and it's again, what's the employer portion of the expense? What can I recoup from the employee? What do I need to report on a W-2? And again, it all works in tandem. Nate, I see you jump in. Do you want to add something here?
Yeah, just a few comments on the payroll and the shuffling of benefits round piece. Many practices we encounter are already using some sort of third-party payroll provider. In terms of compliance and kind of how your benefits interact with payroll, the first thing I'd encourage is many of those providers send out a lot of push emails that are meant to be educational about kind of tax implications and how these different offerings and changes in law will affect payroll. And certainly don't overlook those. Those are free, and those companies put a lot of time and resources into building out those free resources for their users. So some common ones that come to mind that I know for a fact do this would be ADP, Paychex, Paycor, Paylocity, Intuit, the host of QuickBooks, does some of that as well. You could certainly help your CPA relationship might be able to help with that, but something we see increasingly is many firms are starting to leave the payroll services industry. Many times because these third-party providers can provide a generally great product with a lot of resources to back it. So certainly take advantage of those. And to your point of reshuffling benefits, Andy, an example that comes to mind is, I think historically there's been a trend in the veterinary industry where maybe some of their benefit offerings in terms of insurances might not have been as robust as other industries, somewhat because of size and other reasons. I think of a couple examples, but one specifically where a practice is now looking at offering more robust health, dental, vision, long-term care, et cetera, insurances, and they're trying to grapple with the cost with that. And one of the ways that they were able to kind of sell that and kind of manage that cost was, historically they had paid a little bit more in their hourly rates to kind of offset that lack of offering for folks. So they were able to do a cost analysis and help the folks that would be enrolling this realize that their take-home pay would actually be more than it was currently by dropping their pay and taking advantage of these benefits. So using the employee feedback, using employees' opinions and trying to help meet their needs doesn't necessarily have to be a humongous cost burden. It can be mitigated in some instances. That one specifically came to mind.
Thanks, Nate. So again, as we consider that compliance piece, with the IRS and the other state agencies, we've had a lot of clients in recent years, because of your increased profitability, because of your desire to, both take care of your employees, set up your own future, and also save on the tax side. We've had a lot of you update your retirement plans. Okay. And again, I challenge you, there's probably some of you that go to your handbook and it'll say simple 401k when maybe now you have a profit sharing 401k or a cash balance plan. So again, in tandem, anytime you're updating something, think, okay, is this an opportunity to update my policies and my handbook as a whole? I mentioned health insurance, so many options, such a tremendous expense for those of you that offer it. Some of you kind of feeling that you have to offer it, right, to compete. And so you have all different types of plans, especially the ever-growing popularity of the HSA plan, right? Because if you're HSA eligible, you can save on premium cost, but then maybe you're providing, some benefit to your employees, to fund, their higher copay, their higher deductible. So again, all that should be very clearly delineated and listed, in your employee handbook. And again, you're trying to differentiate yourself. Some of you with retention bonuses, some of you with, maybe a year-end employee gathering or bonus. And we always get the question, can I do this? Can I do that? Does it need to be reported through payroll? Do I have to add it to a W-2? And again, all this rolls back into, what you have set up for that employee experience. Touch on this one briefly, but again, it depends on the size, of your practice. And, it can be anything from the potential relocation of an associate cross country, to recruit to your practice, to, sending somebody out to get lunch or donuts, for the day, and everything in between. But again, consider, if you are trusting someone with that expense, with that cost, with that responsibility, what's the approval process? Number one. Number two, once the expense is incurred, what substantiation do you need to comply with, with the IRS? What reporting is required for reimbursing that expense? And as far as records retention, get that question a lot, because think of all the stuff you have to retain in your practice. How long do I have to, keep those records? It's all something, again, to make sure everybody understands on the forefront, and you protect yourself as a business owner from a compliance standpoint. Again, Steve said it. I love how this slide was set up, and it all revolves around your culture. And I always say you can't fake culture. Your culture is what defines you. It defines the employee experience, and it also defines what I like to call the patient experience. And it also reminded me of the must versus should conversation. When you're going through that and you're searching for the musts versus the shoulds, in conjunction with your attorney, think about what exceptions do I need to provide flexibility for. There are times where, yes, it's black and white. I want to be in a box, but at the same time, there are times you don't want to paint yourself in that box, right? You want to give yourself that creative workaround when it's applicable. Okay. Remember, with this handbook, it is a retention tool, and it is also potentially a recruiting tool. And you are in a battle for a limited amount of people. And it seems more limited every day. And those employees, your people, your most valuable resource, they lead to a very positive patient experience. Okay. And ultimately, hopefully, more successful practice overall. One more point here. Remember that I always tell people, if you think you're going to pull an employee aside and tell them something and expect that it's going to stay with them and that they're not going to share, that's foolish. There's always going to be water cooler talk. They're always going to compare notes. So again, make sure you can be as transparent, black and white, consistent as possible with everything that you present to your people. And lastly, for now, Steve covered this thoroughly, but be considerate of, okay, am I in a situation? We used to do poll questions with a lot of our seminars. This will be a great place to ask a poll question of where you sit in your practice. But again, consider, do I really need to completely rewrite my policies and my handbook into one? Are there just some things I need to update, put an addendum in, have a new acknowledgement, sent out? I think it's just, really assess with your trusted advisors, with your attorney, where you are, when's the last time that you looked at this, and, what the appropriate next step is with your handbook. All right. Enough on handbooks, unless Steve or Nate have anything to add. Now we go to what probably is everybody's least favorite subject, having someone exit your practice.
Thanks, Andy. And, when we do these webinars, I really enjoy sitting back and listening to Andy and Nate's perspective and comments, because it makes me realize that we might approach issues a little bit differently based on our professional backgrounds, but we're all in the risk management business. We really are. We work with our clients to make sure, as Andy said, that there's compliance to regulations or laws or whatnot. But even Andy's slide where he had the recruiting and retention circle, understand that, like, having a good solid handbook and communicating well with your employees and having clarity on everything from expense reimbursement to benefits to more progressive discipline, all of the things that both Andy and and Nate have been talking about, it helps to foster recruitment and retention, because generally speaking, most people want to work for a company that they feel like is doing things right. And if you want to be there and you want to stay there, that means it's a lot less likely that you're going to end up with a claim situation at some point. Now, we do live in the United States and it's 2024. And as Andy said, there's a lot of litigation out there. I can tell you, I can assure you, I much prefer working with my veterinary clients and other clients on proactively avoiding risk, preventing risk, and putting my clients in the best position possible to defend if a claim does come along. And I know Andy and Nate would second that. And the handbook goes very nicely hand in hand with this termination firing issue, because if a handbook is done well, it oftentimes is something that will be referenced or could be of great assistance if litigation comes along. So let me just, first slide. Okay, some tips to consider. And some of these might be elementary, at least to some of you, but it's worth just at least making sure we're all on the same page. Because when you terminate somebody from employment, how you terminate it and what has happened, what has transpired prior to the termination, will in a lot of ways impact that risk management aspect that I'm referencing. So making sure termination decisions are well documented, particularly performance issues. And with performance issues, again, these are all things that should be referenced in your handbook. The progressive discipline, the use of warnings, evaluations. You should have a policy in your handbook talking about if you use evaluations. I still have a few clients that don't, and that's fine too in certain cultures and circumstances. But if you do use evaluations, that is certainly a document that comes into play to help support the legal validity of a termination decision. PIPs, a lot of companies use those, and they are very helpful. Sort of like oftentimes is the last chance to improve, and that's reflected within the wording of the PIP. So make sure. And when I talk about well documented, that doesn't mean just having a PIP is enough. That PIP has to come across as being very professional, well worded, and you just want to make sure it is done correctly. So now misconduct terminations are a little bit different, because if you have a misconduct, which would be something like anything from discrimination or harassment or theft or gross insubordination, vandalism, all those types of things, those tend to be less document intensive, although certainly you may have a handbook policy that says these are items that would be grounds for immediate termination, including but not limited to, again, the following. And that's where a lot of the misconducts are listed. Once you have determined that a misconduct actually happened, the termination should be immediate. Whereas with the performance, it may need to, a story might need to play out. Does the employee respond to the warnings or the evaluations or the PIPs and reverse course and improve so that you don't have to terminate them? That's ultimately what you want. You don't want to progress to a termination, because once you get to that termination, that's when sometimes fingers start getting pointed, and it must be because of my age or my disability or my gender or my race or any protected class, fill in the blank. It's not because of my poor performance. Use a termination letter. Again, it's a document that can be very, very useful and helpful if litigation develops. Should not be a lengthy termination letter. I am talking 2 or 3 paragraphs at most, but it is something that I strongly recommend. When you have a termination meeting, make sure at least 2 management level employees are present. Oftentimes it will be, an office manager, practice manager, plus an owner, or depending on the size of your organization, it may involve a supervisor, an HR person. Just make sure there are 2 management level employees present. One should be doing the talking and the other one is frankly there as a witness and maybe to take notes. Don't have lengthy termination meetings, okay? They need to be brief and to the point. If they're more than 5 minutes, they're likely too long. I had one situation a number of years ago where the documentation was great as far as justifying the termination, and the HR person just was not very experienced. It got drawn into a conversation, and during the approximately 1 hour long termination meeting, a question was raised by the outgoing employee as to, what are you looking at for my replacement? To which the response was, well, we'd like to get somebody with less experience than you. Well, less experience, that's an odd thing to say. And guess what? They got an age discrimination claim in large part because of what was discussed during that meeting. And it just went down a rabbit hole well, once that comment was made. So don't get drawn into long termination meetings. They should be to the point. Effective today, company made the decision to terminate because of your excessive attendance problems, which we have discussed with you previously. We will be providing you later by the end of the week or early next week, a formal termination letter and a severance agreement if you decide to use a severance agreement. And I know Andy is going to be talking about severance pay. My one comment that I would say is it's a big decision whether to provide severance pay. It's not a legal requirement, it's discretionary. And there may be some situations where it makes sense. For example, if you are going through a restructuring and laying off 10 people and want to give them something, a severance agreement might make more sense there. With somebody that's been terminated for misconduct, I would question whether you ever want to do a severance agreement. If it's a performance issue, you may want to keep it in your back pocket. You may want to be proactive with it. And when I say keep it in your back pocket, I mean, wait to see if the employee files some type of claim, and then consider severance or separation pay at that point. So more to come on that. But my point is, at a termination meeting, don't give a termination letter or a severance agreement at that point, because the employee is going to start looking at it and is likely to have questions about it. And it just risks lengthening the meeting, which means you could go into topics you don't want to get drawn into. So just wait. You don't have to give them a termination letter or a severance agreement right at that termination meeting. And by the way, a lot of times people are very emotionally charged, whether they're angry or just saddened by the separation. It's not the time to do that, in my judgment. And you may also need to send a separate letter on COBRA 401k benefits type issues. A few other things about terminations. And this is one sentence, but it's a very important sentence. Consider security options if any workplace violence concerns are present. And there's lots of security options, from something as simple as notifying local police that you're terminating somebody's employment. That might be a little bit more dicey. And local police will probably say, well, what time is this going to happen? And they may just be more present in the area. I've had that happen. I've had some clients decide that they needed to bring in an armed security guard. I've had others bring in a security person who was not in uniform. But you need to think about that. I'm not saying every situation where you terminate an employee requires security, but if you think it might, err on the side of caution. Just a few final things before I turn it back over to Andy to give his thoughts on this issue. Make sure you've addressed return of company equipment, property, or documents. That should actually be a policy in your handbook that at the end of employment that needs to happen. Sometimes company equipment or property and even confidential information can be very, very valuable to your organization. So make sure that that is addressed, and make sure that preferably it is returned before they leave. Now, if they have some things at home or in another location, you may have to set a date for that to happen, but make sure that's addressed. Also, if you have post-employment obligations, non-disclosures, non-solicitations, non-competes, remind the employee about those at the termination meeting. Doesn't have to be a lengthy discussion. And you could provide copies of the post-employment agreements to the employee because maybe they forgot about them. Don't do it at the termination meeting. Okay, attach it to your termination letter. You can have a sentence in the termination letter that says, as we mentioned, you are for the next 12 months, 18 months, whatever, under the post-employment obligations that are set forth in the attached non-disclosure agreements and non-solicitation agreements, something to that effect. It's an effective way to make sure that employees are more likely to pay attention to those types of obligations. I'll shoot it back over to you, Andy.
Awesome, Steve. Thank you. As we look to, wrap up here, I just want to give you a few practical observations, maybe the most common questions that Nate and I get when working with practices. A couple things. A lot of times you can potentially avoid headaches on the back end if you have a really good interview process, okay? And so I always encourage people, start with the end in mind, okay? Hope for the best, but always be prepared for something not working out. So again, interview, consider your culture. What effect is this individual going to have on my people, my culture, the patient experience? Yes, sometimes we feel like we're desperate right now for people, but always know, trust your gut. Is this a workable situation? Is this a training issue? Is this individual willing to learn, or is it just not a good fit? And if it's not a good fit, you all know, I encourage you, move on quickly, but be careful and always consult, involve your attorney, especially again in this age that we live in right now. Okay. A few other things. A lot of times clients are so surprised to find out that, as Steve said, from a legal perspective, severance pay is not legally required. A lot of people are like, well, don't I got to give them 2 weeks? And a lot of times, as Steve alluded to, it's more of that bridge, to allow the individual to potentially find other employment, soft landing, whatever you want to call it. But again, many are surprised to find out, not a requirement. None of this that we presented is a one size fits all. So please consider the situation. A lot of times what's overlooked is the separation agreement, termination letter, severance agreement, whatever you want to call it. But I think Steve made that very clear. Again, I would encourage you, especially in an associate level, dicey situation, be consistent, but have some type of formal, hey, this is how we're parting ways, on top of everything else that Steve said from a legal perspective. We get a lot of questions on payout of, accrued continuing education allowance, time off allowance, I was just about to pay a retention bonus. And again, some of this, is it a must? Is it a should? Do you need to? No one size fits all. A lot of it is hopefully covered in your handbook and your policies. And if it's not in conjunction with your attorney, it can be delineated in your termination agreement.
Hey.
Not so much. Go ahead, Steve.
Yeah, just one quick comment on the payout of vacation or PTO or whatnot. One common misconception, and Andy has alluded to this, but I want to underscore it. One common misconception is that if you offer vacation and PTO benefits, that if there's an accrual, that it has to be paid out at the end of employment. That is not accurate. The state of Wisconsin has said, for wage claim purposes, they will hold the employer to whatever your policy says. So I have clients that state in their handbook policy, there will be no payout of any vacation or PTO or sick time regardless of the reason for the separation, termination, resignation, retirement, whatever. I have others that will do it for a performance or a resignation, but they won't do it for a misconduct, and they say that in the policy. My point is your handbook policy will be binding on the company with what you do with payout of CE vacation or bonuses. Thanks.
That's really good. Thanks for making that point. Last two things may not be applicable here, but again, especially in this, world where, people are trying to find that flexibility to do some work remotely from home, make sure you consider any equipment that you own. And this could be a whole separate topic. I hate that it's the last point, but it's all about message, right? And so when someone leaves your organization, what's the message to the remaining people? So critical. And in some cases, if it's a key, long-time, well-known employee, what's the message to patients? And so do not overlook the message. Be as transparent, honest as you can without getting yourself into more trouble, but always consider that message. All right, we're right up to our time. So Lee, I will leave it to you to wrap us up.
All right, guys, you are not only up to the time, you're over the time. There's so much information here. It's, I feel like we could keep going too, because a couple of the questions that we did have come in were pretty broad. And Steve, I'm sure you could take some more time and talk about this stuff. But just real quick, while we wrap up, a couple things. A person had asked about what PIPs stand for. So just to make sure that people who understand some of the acronyms, performance improvement plans, you can certainly look those up. And then Steve, I want to give this person an opportunity to get their question answered as well. And the question was, can you terminate an employee for calling in sick too much, even if he or she provides a doctor's note?
The answer is probably yes. The reason I say probably is because certain medical conditions are going to be disabilities under the ADA and Wisconsin law. And sometimes there may be a need for a reasonable accommodation for a leave or whatnot. But things like the flu or a bad cold, those are not permanent conditions that are disabilities. And so for that type of more common attendance issue, that type of thing can lead to termination. But just be very careful if it is more related to a chronic illness that could be a disability.
Great. All right. Thank you for answering that. Steve, Andy, Nate, as always, awesome information. So much there. As we wrap up, I just want to let everybody know you can go to svaaccountants.com to sign up for the other webinars in the series. You can also find news and information that may affect your business. Our next webinar is November 12th. It is our all-important veterinary salary and benefits survey. So we will be reviewing the results. It'll be the only opportunity for you to see those results if you didn't participate. So I would really recommend you sign up for that and see what is happening in the veterinary market around the state. I just want to remind everybody that the SVA team is only a phone call or an email away. So if you're a client, reach out to your SVA professional as questions arise. If you're not currently an SVA client, you can contact me, Andy, or Nate, and we can get you the questions, or we can get your questions answered. Thanks for attending today. Hope to see you at our next webinar, and we hope you enjoy the rest of your afternoon. Thanks a lot.